Taking a short break. Perfect time to bring in for this hour criminal defense attorney Sam Bassett. Sam, thank you, of course, for joining me, being on Court TV. So we get a lot of insight into the defense's case through this defense witness talking on redirect about impulsivity and the suicide, defensive avoidance, all of these things that they are introducing to say to this jury, not she did not shoot, but rather, yes, she did shoot, but these are all the reasons why you should find her guilty of a lesser crime. At least that's what I think they're doing.
Absolutely. This is a situation where you can't deny the act that occurred. You're trying to get inside the head of the defendant through professional testimony so that a jury, already perhaps sympathetic at the whole context of the breakup and situation like that, is also understanding that she was also dealing with some organic and psychological issues for periods of time before this happened. So yes, they're trying to move the jury toward a lesser offense and a lesser finding of a lesser state of mind.
So knowing that she doesn't deny firing the shots, does that make it more likely that she's going to testify?
It is pretty risky to put her on the stand. I think that they're doing a good job of putting the context of the shooting, and also they're doing a good job of showing her fragile state of mind. So it's a risky move, in my opinion, to put her on the stand, given the evidence that I've seen today.
And I have to tell you, though, I do wonder what her demeanor's like. And so I do know, and I just have to ask you quickly, how much is it incumbent on you in the last 20 seconds to figure out what the personality, demeanor of your client may be like, to take that into consideration about whether or not they should testify?
Absolutely. You run your client through mock trials and mock cross-examinations to kind of test that, how they'll be under fire in the courtroom. So, yeah, you have to look at that.
Yep, absolutely. All right, Sam, you stand by for me, please. We are waiting for court to return from their break, and then we could find out whether or not Daniels will testify in her own defense. In the meantime, Court TV's own Kelly Craft joins us live for an update out of Virginia, where a jury has reached a verdict in the civil trial for Abby Zwerner. Hear what her attorneys had to say after the jury decided in her favor, and after that jury awarded her $10 million. That's up next. Stay here. A jury found former assistant principal Ebony Parker civilly liable for ignoring those repeated warnings that the child, the 6-year-old, might bring a gun to school. That finding raises the bar for every school employee because duty of care now carries real consequences. But even with a $10 million award, big questions remain. Payment is expected to come from the Virginia Risk Sharing Association. Now, this is an insurance pool for public entities, yet that coverage comes with limits. For instance, it may cap payouts below $10 million, and it may not pay at all if the employee, for instance, is ever convicted of felony criminal charges related to the case. Further, it is likely to face appeals and could always be settled for less. So while the verdict sends a powerful message about accountability, the reality of who pays and how much is still very much in play. In civil court, consequences reach far beyond the headlines. Those are my thoughts from the bench. Still with us, criminal defense attorney Sam Bassett. Weigh in, Sam, on what might happen with this award, knowing that it also creates a duty, I think, on school employees in these circumstances.
It does definitely put some pressure on school administrations and school policies to perhaps be more active in responding to these incidents. I think it may cause school security officers to have special training and a quicker response to these kinds of allegations. I also would echo what you said about the award. The award by a jury is oftentimes just the beginning of a several-year process to determine what actually will be paid. You have to go through appeals, and oftentimes you have a mediation while the appeals are pending to try to, from the school's perspective, to try to knock down the award.
And talk to me about foreseeability and the fact that it was a 6-year-old. Do you think that this at all means, the way it stands right now, that in the future schools should foresee that even a 6-year-old might bring a gun to school?
this is where an appellate court could weigh in on that standard. The gross negligence standard is pretty high. So is the foreseeability issue relates exactly to that. And a lot of times jurors in a trial, feeling the emotion of the situation, will find for the standard being met, where an appellate court might have a more objective view of whether or not that's a standard that we really want to fit to these facts, whether or not the evidence was sufficient to show that. So yes, it's a very interesting finding and lawsuit, because the child was so young. I don't know that anybody would ever fathom a child that young would actually have a gun at school.
Yeah, I agree with you, Sam. I think that's part of the difficulty, is believing that a 6-year-old, A, would have a gun, B, it would be a loaded gun, C, it would be a real gun, and D, that he would even use it or know how to use it to actually injure someone. Pretty significant long-term injuries to the plaintiff in this case. Stand by, Sam, if you would, please. We need to take a break. Up next, more of the Broke My Heart murder trial in Tennessee. Will Latoshia Daniels testify in her own defense? That is the big question. I can't wait to find out. We may find out soon. Stay with us. All right, still with us, criminal defense attorney Sam Bassett. Sam, a lot of details about what happened. The wife sounds very calm. Granted, this happened back in 2019, so it was, what, 6 years ago, if I did my math right, about. And talking about, she doesn't understand. She doesn't know what's going on. She actually follows the defendant back in the house. What are your thoughts as she is telling this narrative about what happened that day?
Well, my first reaction was how matter-of-fact her style is a little bit. But again, the passage of time and maybe the discovery of this affair has kind of calloused her heart a little bit. It seemed like she was very calm in describing what had happened, where I think most witnesses in her situation might show more emotion and might have a hard time getting through all the details. But she seemed to be reporting it in a very matter-of-fact fashion.
She sure did. I want to listen together now, Sam, because there was another witness, law enforcement, Chris Roberts, who talked about what the wife had told him about the fact the defendant shot her, the wife. Let's listen.
Going back to your interview with Ms. Perry at the time.
Okay.
Okay.
Yes.
You also found out that she had been shot.
Correct.
And you also found out that she didn't believe Ms. Daniels had tried to shoot her.
I don't recall that. I recall Mrs. Perry telling me that she tried to cover her husband to protect him, and that the defendant shot her.
All right, so she doesn't believe, Sam, that the defendant meant to shoot her. She was trying to protect the husband, and she got shot. Does that make a difference for a jury in a conviction of this defendant, in your opinion?
Yes, it does make a difference. I think that her anger or her mental health reaction toward him is not what she did, but the emotion of it, or the impulsivity of it, is understandable with regard to him. Now, shooting her is definitely a more difficult thing for the defense to overcome if she meant to shoot her as well.
Yeah, I agree, and it sounds like she didn't. I want to mention this. We see this seal right now. We're waiting for them to come back from a break because the judge wasn't on the bench, but look at that, Sam. We willed it to happen. The judge is back on the bench. Let's see if we have audio and can go back in together. Done a little differently. The judge did not question her. Her attorneys did very thoroughly, and the judge concluding that she knowingly and voluntarily has chosen to testify. They are standing now waiting for the jury to come in. Sam Bassett, your thoughts, and I'll cut you off if we get started, but what do you think?
That was a little bit different way of handling the Fifth Amendment. I thought she was going to say she was not going to testify.
Me too.
But at the same time, I think her lawyers are being careful, and they want the judge to know that it was a thoughtful decision for her to testify. So very interesting way of handling it, but it had to be done one way or the other, I suppose.
And it may be this particular judge prefers the attorneys do the questioning because they're comfortable with their client. I have no idea. I'm totally guessing, but it's just a little different to your point. Next question, do you think perhaps the advice of the attorneys was do not testify? The defendant always gets to make that choice, and maybe that's why counsel said, no, I need to put her under oath and ask these questions to protect us as the attorneys. Could that be?
That absolutely was running through my mind as they were being so detailed and so thorough in their questioning that maybe they had said, look, we don't advise that you testify. And she said, I don't care. I want to exercise my right to testify. So absolutely, I agree that that could have happened.
Yeah, and do you think there's, because of the fact she does not deny shooting, I don't think it's as big of a risk for her to testify. I think I understand why she feels compelled to testify. Your thoughts?
I agree. I mean, I think in her mind now, she probably feels like she wants to get up and tell her side. The risk in it is if she comes across in a way that the jury is very unsympathetic or the jury feels like the mental health issues were just kind of a ruse if she comes across coherent and articulate when she testifies.
And I think part of the problem with that, Sam, is the day of in 2019, I can promise you, is probably very different than where she is mentally today. All right, we're out of time. Sam Bassett, thank you so much for being with us, as always. Coming up next, Michael Ayala joining me. This is going to be some compelling testimony you do not want to miss. The defendant, Latoshia Daniels, she is going to be testifying in the Broke My Heart murder trial. Stay with us on Court TV, your front row seat to justice.